This webinar. My name is Diana Tsutiva. I'm counsel at Foley Hoag and a member of the TIAC 45 Steering Committee. Today's webinar on hybrid mediation is first in a series of webinars leading up to the Uzbek Arbitration Week, scheduled for the week of September 6th to 10th, 2021, and organized by the Tashkent International Arbitration Centre at the Chamber of Commerce and Industry of Uzbekistan and TIAC 45. If you want to know more about hybrid mediation modes, this is the webinar for you to attend. And today we'll welcome three prominent speakers who work in this field. First, Mr. Wee Meng Chuan, who is the CEO of the Singapore International Mediation Centre. Wee Meng is the prior to joining the Singapore International Mediation Centre, he was the general counsel of IBM China based in Beijing. And he was a court litigator before going in-house and has worked as general counsel across several countries over the last 20 years. We have Chiara Tondini, who is counsel and mediator at SLCG law firm in Italy. And Chiara is the founder and manager of the Florence International Mediation Chamber and the Florence International Dispute Resolution Academy. And she has extensive experience in mediation, arbitration, and other ADR services. And we have Mushegh Manukyan, who is the manager of the Mediation Unit of the Ombudsman Office of the United Nations Funds and Programs. And he's responsible for, among other things, building and overseeing the Global Mediation Panel and mediating workplace and commercial disputes involving UNICEF, UNDP, UNOEPS, and UN Women and other agencies of the United Nations. Before joining the United Nations, he practiced international dispute resolution at Three Crowns in Washington, D.C. And he was a senior counsel at a Texas-based high-tech company managing Russia and CIS, India, the Middle East, and other parts of the globe for more than 10 subsidiaries of the company. So we're really delighted to have our panelists here. And in this webinar, we'll explore hybrid mediation, when to use it, and what are the best practices associated with hybrid mediation. And we'll start with Wee Meng. Wee Meng, how do mediation and arbitration differ? This is the foundational question.
Thanks, Diana. What a pleasure it is to be here. I wish I'm there in person in Tashkent, beautiful Tashkent, but I'm afraid with the restrictions, this will have to do. We'll meet in person sometime soon, I hope. As to your first question, Diana, we teach our mediators in your opening statement to say exactly that. What is the difference between arbitration and mediation? In arbitration, as you know, decision is made by the arbitrator. He makes a finding and then he gives the parties an award. In mediation, the mediator does not make any finding or make any decision for the parties. It is for the parties to decide what is the best solution for them. So it's a very different process between the two. In arbitration, it's adversarial. They will sort of go at each other and try to find the best position for themselves. In mediation, the parties do not fight, although they do fight initially, but the objective is to get them to work together collaboratively to find a solution that will satisfy both sides, find a solution that's outside the normal legal rights of the parties. And I can happy to give some examples later. And then the third one is really, at the end of the day, very important to all parties, the question of costs and time. Arbitration, as much as it is a wonderful process, and we will always have arbitration, it is a little bit more expensive than mediation, just because of the way the process is set up. An arbitration can last for anything between 6 months to a couple of years even. Mediation usually is set up within, I would say, 2 months at most. An arbitration can last a couple of days at least. And in mediation, at least in SIMC, we usually get it done within a day. So the cost is very different, and the ability to set it up for the parties to meet is also very different. In this day of online mediation, and maybe Diana, this is a good time to just show that photograph that we have. We had a mediation here. We've been having mediation here on a regular basis. I would say every week, about 2 or so. And the photograph that I took is a real mediation that take place in this time of COVID-19. I hope Diana will be able to find that particular photograph. No issue, we can show that later as well. But what I'm trying to show is that in this day and age, once you have the parties available, you could have that online, you could have the parties call in, you can have the lawyers who are present, be on standby or be there physically, and the parties can, oh, thank you, there you are. So this is an actual live mediation that happened here in Singapore in Maxwell Chambers. Just to tell you it's real because that's me in front with slightly balding at the back of my head. And all the parties are there in person, and we have permission from everyone to take this photograph. So we're not breaching any protocol here. And the parties were calling in from overseas. One was from Hong Kong and the other party was from Japan. Obviously, we don't have the faces of the parties shown there because that's confidential. The person that you see on the screen is actually George, my chairman, shown on the screen there, which is what the parties would see. So in a very closed setting, as you can see, we sit in a circle rather than facing each other. We're able to try to resolve this issue that we have. This was a complex issue regarding a joint venture in one of the 2 countries that I mentioned. So yeah, so that's kind of the major difference between mediation and arbitration in the area of who decides the final outcome, the adversarial process versus collaborative process, and the cost and time.
That's great, thank you. Chiara, perhaps you can share with us what types of mediation are available to help resolve disputes?
Yeah, first of all, I want to warmly thank the TIAC and all of you for this invitation. It's indeed stimulating to be here and addressing such an interesting topic today. Well, the theme of available types of mediation is immensely wide, so I will attempt to address it in a nutshell. When tackling the mediation process, it is crucial to take on mind that we are not dealing with a unique and straightforward one. Mediation, in fact, acts substantially differently depending on the legal and cultural context in which it has developed and in which it is utilized. So, let alone what mediation is and its definition. Talking about types of mediation leads to address the theme of mediation styles. Basically, the mediation style pertains to the role played by the mediator in the process, or the different role played by the mediator in the process. In theory, there are usually 3 types of mediation that are often discussed, which are facilitative, evaluative, and transformative. When adopting the facilitative style, the mediator merely assists and guides the parties in trying to reach an amicable settlement without making recommendations, giving advices, or proposing outcomes. In this style, it is crucial the use of communication techniques by the mediator. We can imagine the mediator acting as a bridge to properly deliver information between the parties or among the parties in case of multi-party mediations. As per evaluative style, in this style, the mediator focuses on parties' legal rights rather than on needs and interests, figuring out what an adjudicative body would likely do, whether court or arbitral tribunal. He or she can make recommendation, and formally or informally, depending on the concept of mediation which we are carrying out, but in any case, influencing in so doing the outcome of mediation. And usually the evaluative mediation style is used and has substantially developed in court-mandated or court-referred mediation. Lastly, we have the transformative style, which is the newest among the three. And transformative style aims to transform the parties' relationship through the recognitions of other parties' needs, interests, values, and point of view. So it's a sort of entering in each other's shoes. Okay. And a peculiar feature of transformative mediation is that it is entirely conducted in joint session. So in transformative mediation, we don't have the use of caucuses, and the mediator doesn't meet the parties separately. So of course, there is all the consequent implication in terms of use of confidentiality and so on. In international mediation, facilitative is the style of mediation that is most often encountered. And I don't have a scientifically based answer to that, but I assume that it is probably because it is the easiest to adapt to parties from different legal backgrounds and culture. Concluding, I say that the style adopted by the mediator represents an important factor to be taken into consideration by parties or appointing authorities in the mediator selection process. Usually, mediators' profiles published on institutional or personal websites outline the styles applied by the mediator. And this is a very helpful information in order to make an idea of the most appropriate mediator to be appointed for the case at hand. But I stop here as I assume that this aspect will be duly addressed later. So thank you.
Thank you, Chiara. So Mushegh, tell us please about the difference and what's common between mediation arbitration hybrid and arbitration mediation hybrid. What is that about?
Well, first of all, thank you very much, Diana and TIAC, for organizing this event and having me. I'm particularly, I think, very happy that TIAC and other institutions in the post-Soviet Union era are thriving, and that's my personal kind of an interest to be part of this event as well. So congratulations to you for putting together this wonderful event. And also I'm very happy to speak about mediation because that has been my passion for many years. And sometimes my wife even jokes and says you have two wives and it's not clear which one is the beloved one. So this is the time that I want to show my second wife and talk about that. So it seems, we were here to talk about how effective one can use the mediation arbitration or arbitration mediation model. And as Diana suggested, the title even of Med-Arb and Arb-Med already suggests that Med-Arb means you move from mediation to arbitration, and Arb-Med means that from arbitration you move to mediation. And we can discuss how the process works, but I wanted to suggest two things that will be probably helpful for our audience. One would be, if we are speaking about Med-Arb, from an institutional perspective, the main difference between the two is that Med-Arb is typically a contractual mechanism, which means that when business people are just about to sign a contract, they think about various ways to structure their dispute resolution clause. And one of the things that comes to mind is Med-Arb, meaning let's just try to resolve amicably. It could be first negotiations and then mediation and then arbitration. And that can involve also other mechanisms. When you are already in mediation, then maybe the parties will say, well, the mediation SIMC doesn't work. Can we go to arbitration? But it's rare. It's not that when you are in mediation, then you will structure it could be common that the parties would trust the same mediator to act as an arbitrator, and that opens the Pandora door, of course, of the the confidentiality, that opens the ethical rules and everything else, whether the mediator can be an arbitrator. Maybe we can discuss that if someone has a question. But I wanted just to highlight that from an institutional perspective, the Med-Arb typically starts as a contractual mechanism. As opposed to that, if we're speaking about Arb-Med, it's typically a mechanism that is inserted in the arbitration rules. So you may see, and I'm going to give you at least 2 examples of recent changes in 2 of the institutions which exist in the United States. And I'm sure there are some centers internationally who are using the same model. But typically, when you're speaking about Arb-Med mechanism, it's that arbitration institutions would like to encourage the parties to use mediation models. And one recent example is JAM's mediator in reserve policy that actually they put together. It was existing before, but now the system exists as of 1st of June 2021. So it's a very recent development, which means in every arbitration, JAM says, I have a mediator in reserve. By the way, the arbitrator will not know that who is the mediator. The parties will identify that mediator, and the mediator will not know about the appointment, but that mediator will be free of charge on reserve. When you want to activate that mechanism, the mediator will come on board, assist the parties, and then if it's successful, you can abandon the arbitration and settle the case. If it's not successful, you can proceed with arbitration. So that's one mechanism that the arbitration institution can offer. Another example that I want to give you, it is the International Dispute Resolution Procedures over AAA, American Arbitration Association. That was very recently, they changed their rules, which is effective as of 1st of March, 2021. And again, it creates, very interestingly, it creates a presumption that the parties will mediate during the arbitration process, with any party being able to opt out, of course. And there's a very interesting clause in the arbitration rules that says that any agreement of the parties, otherwise, if the parties have not agreed otherwise, or if the right of any party to elect not to participate in mediation, the party shall mediate the dispute. So there is a presumption already in the arbitration rules that the mediation will take place unless the parties will opt out. So those are the mechanisms that you will see in the rules of the arbitration institutions. I mean, of course, you can see arbitration cases where parties voluntarily or by the nudge of the arbitrators, that's again, opens up some difficult question of ethical dimension and so on and so forth, whether an arbitrator can suggest mediation. But typically that can be the case, that in arbitration, parties themselves come to the point where they would like to use mediation at a certain point of arbitration and then see whether they can settle the case. If not, they can proceed with arbitration. Let me stop here and then pass the floor over Diana, and we'll have a lot of opportunities to go into some of the details of our Med-Arb and Arb-Med models. Over to you, Diana.
Thank you so much, Mushegh. Yes, it sounds like that's the recent changes in the rules reflect this trend towards hybrid mediation and the importance of that mechanism in the settlement of complex disputes. And I now want to turn to all of our panelists with a question of, in your experience, and you have varied backgrounds, what should be the main factors and considerations for the parties in selecting Med-Arb and Arb-Med mechanisms? And Wee Meng, we'll start with you.
I'm on mute. Yeah, thank you, Diana. It's a fascinating world of how it's just taking on different changes as we proceed. And I shared a study with Diana a little earlier, which I thought you will find interesting. This was a study done by Queen Mary and White and Case. You see in Diana's backdrop, there's White and Case there as well. They've been doing this study very consistently for many years, and every 3 years they do that. And I found this latest one, 2021, most fascinating. In the question, the question is asked by the surveyor is, what is your preference for international dispute? How would you like your dispute being resolved? Is it by an international arbitration plus ADR, such as mediation? Or is it by international arbitration alone? And there are other options, but these two really stand out, which is why I've highlighted that for you. Now you will see that in 2015, on the left in gray, 34% of the respondent said they would prefer international arbitration. And 56% of them on the right, you will see they prefer international arbitration alone, not what we call a hybrid system, international arbitration and ADR. That's 2015. 34% against 56. And then in 2018, you see 49%. And finally, in 2021, 59%. There's a sharp rise in 6 years, 2015 to now, how parties now prefer a hybrid system, what we call a hybrid system, international arbitration and mediation, or other ADR like facilitation, etc., and as well as the drop in just international arbitration alone. And when I show this to a lot of my friends in the arbitration world, they are very concerned because they say this is a trend that, you know, it doesn't look like it's going to change anytime soon because it's so dramatic. And so I thought it would be interesting to share this with the participants. You might want to check this out on this Queen Mary survey with White and Case. So to your question, what are the factors that the parties consider when they consider either Arb-Med or Med-Arb? I think I mentioned cost and speed. Obviously, that's a major factor that they consider. How much is it going to cost? Am I going to save some money if I do it by mediation without going to arbitration? That's certainly one factor. Another factor is the speed itself. Sometimes you do need a very quick resolution, especially in the time of COVID-19. The company might collapse before you find a resolution. And arbitration, a fantastic system, but it does take a little bit of time and it requires that time. So sometimes mediation might be a better way to find a quick resolution for the survival of the businesses. And the last one would be enforcement, which obviously is very much in the mind of a lot of parties. Is it enforceable at the end of the day? So this is where the Singapore Convention comes in, and we'll talk a little bit about that later. But the idea now is with the Singapore Convention, more and more countries adopting it and ratifying it. By the way, Brazil just ratified it not too long ago. I understand Turkey is going to ratify it very soon. I think the news just came out like 2 days ago. So more and more countries are ratifying the convention, which will help mediated agreements to be enforceable. So that will, over time, and it will take some time before it becomes accepted in some of the other countries where enforcement becomes, like the New York Convention, enforceable of arbitration awards. So I think those are the three main factors that I see: time, cost, as well as enforcement.
Thank you, Wee Meng. And Chiara, would you like to add anything to this from your perspective?
Yeah, sure. Of course, I have only to echo what my esteemed colleague just said about the advantages of mediation and the interaction between mediation and arbitration. Mediation is undoubtedly a time and cost-effective tool, so explore possibility of amicable settlement is always worthwhile, the attempt. In my view, additional factors which should be considered are the following. Of course, for Med-Arb, efficiency. So in international commercial conflicts, a business thinking approach, it is crucial. So both parties are usually interested in resolving the dispute at the earlier stage possible, which is consistent with what the previous speaker has already said. And for both mechanisms, I mean, Med-Arb and Arb-Med, there are situations where an adjudicative outcome, whether court judgment or arbitral award, may be detrimental for one or more of the parties, and therefore reaching a settlement is preferable. And in particular, parties may realize that before the commencement or during the arbitration process, in any phase in which strengths and weaknesses of the case become clear. So here comes the advantage and the plus of an hybrid process and of an interaction and a continuous interaction between mediation and arbitration and vice versa. Moreover, I think that hybrid process can be particularly smart in cases in which it would not be possible to prevail without substantially jeopardizing IP or trade secrets, the company IP or trade secrets. It is the so-called principle of lose the secret or lose the case, which means it is not possible to meet the burden of proof without jeopardizing or definitely damaging the asset, the IP asset of the companies. And in this case can be very beneficial to reach a settlement. Finally, I repeat what, but I think that it must be repeated, as I am definitely convinced about it, that our Med-Arb mechanism may be appealing where a priority for one or more of the parties is enforceability of the settlement agreement. Of course, at this point in history, it is paramount for all of us actors of the international dispute resolution landscape to encourage ancestral state parties to sign and then ratify the Singapore Convention on Mediation. But until it won't be enforced, hopefully soon, on a uniform global basis, the consent arbitration award will remain an instrument to be taken into consideration. And not only until then, as it is interesting to note that the convention itself admits and legitimizes the consent award, as under Article 1, Paragraph 3, it is provided that the convention does not apply to settlement agreements that have been recorded and are enforceable as an arbitral award. So I think that there is much room for the use of hybrid process in order to meet parties interested from legal and economic and business perspectives.
Thank you so much. Thank you. And Mushegh, I'd like to hear from you the same question of the main factors and considerations for selecting the hybrid mediation. And perhaps if there's an opportunity to touch upon the CIS world and how that comes into play there.
I'll keep it very short, Diana. I think, as you can imagine, I would say there's never any harm of considering mediation for any type of dispute. There are some parties who would say, oh, mediation is a great tool, especially lawyers, but it's not for my case. It's not for my case. You go ahead to mediate, but not for my case. I always say, even in the office of the Ombudsman, when people come to us, your case could be the perfect case for mediation. And one reason that I hear always about the Med-Arb or Arb-Med, any type of usage of mediation, they say, what if I use my time and then it fails? So it would amount that I lost another 2 months in mediation, especially for complex disputes. It can, as my colleague Wee Meng said, it can take up to 2 months. So essentially, if there's a failed mediation, failed meaning no settlement, I mean, there's a different ways of addressing what is success in mediation, but if you consider just that parameter, that the failed mediation means no settlement, what if I lost another 2 months? Whereas I could have spent, in arbitration and maybe spend another 6 months or 7 months and get my award. I always say there is a benefit, and by the way, significant benefit of having a failed mediation, because you get a chance to hear what was the concern of the party, to have a chance to freely set an confidential space to discuss some of the issues. And then even if you didn't settle, especially in the ECIS system where mediation is not that common in international commercial disputes and so on and so forth, I think there's a lot of things that the TIAC and other institutions can do to educate people that there's a benefit even if mediation has failed, because you have an opportunity to see the other party. Maybe sometimes that's the first opportunity to be in the same room with the other party. Hopefully after COVID, people will have chances to be in the same room and then shake hands, even if they don't want to, but shake hands and then be in the same room with the participation of the mediator. I'll stop here.
That's great. Thank you, Mushegh. I'd like to move to the next question, which is equally important. In your experience, what role do international organizations play in promoting and supporting hybrid mechanisms of mediation? And I'd like to start with Wee Meng, please. Thank you.
I think the first thing we need to do is to collaborate, right? So I think this is a wonderful opportunity that we are collaborating with a very diverse mediation centers from different parts of the world, and that's what we need. We had Diana visit us, TIAC visited us in 2019. We're just talking about it before the whole COVID-19 pandemic, and we would have more exchanges except for the pandemic, but that's what we need to do. We need to have centers working hand in hand to promote mediation. And we need to talk to our lawyers, right? When the lawyers talk about ADR, alternate dispute resolution, some of it call it alarming drop in revenue, ADR, alarming drop in revenue. We have to address that issue as lawyers. I'm a lawyer, and many of us here are lawyers practicing, and we can understand the concerns. But having seen the light of how mediation can help parties, a lot of the law firms now being more progressive, being more open, do see the benefit of how mediation can be one of the tools. It's not the only one. It's one of the tools that they need to have in order to help the clients. And if the clients see that, hey, my lawyer's on my side, not just fighting it, but helping me to solve the problem, then you have a client for the lifetime, right, of the firm. So that's what we are helping the parties to see. And as international organizations, we have to do that. We have to have more webinars like that, thought leadership. And the other thing that we have been doing, perhaps we can consider with TIAC and others one day, we set up a joint protocol with the Japan International Mediation Centre, JIMC. JIMC was set up maybe about 2-3 years ago. We had a very official signing between the two centers. We had our Minister of Law, Japan had a Minister of Justice who took part. We had this wonderful signing where we said that, hey, when there is a case between Singapore and Japan and other parties, etc., let's consider co-mediation. That's so exciting, so exciting. So after we signed the convention, that protocol, about 2 or 3 months later, we have our first case. One from Japan, party from Japan, and another party from an Asian country. I won't mention which one. And we had one mediator from Japan and one mediator from Singapore. The two mediators worked together over 3 days. They set aside 3 days. They had a matter resolved in 2 days. All right, that's the beauty of it. And it was a massive arbitration matter that they decided to try this joint protocol between JIMC and SIMC. So it's a wonderful story that got a resolution at the end of the day. The two mediators were able to help the parties through very difficult, complex technical issues, more importantly, cultural issues. how does Japanese party see the solution, negotiate, and this other Asian country, which is not very different from Japan, how they see this, and then eventually, with the help of the mediators, they will be able to overcome the cultural challenges. So that's how I see how international centers can collaborate and work together.
No, that's great. I do think that, although it's not part of this webinar, but one of the fascinating aspects about mediation is, its success in different parts of the world, and whether it can be actually equally popular throughout the world. But this is maybe a topic for a future webinar, but I'm really glad that you're touching upon it, Wee Meng. Chiara, from your experience, what is the role of international organizations in promoting hybrid mediation?
Yeah. Well, generally speaking, and just in addition to what has just been said, I would add that further to international mediation and arbitration providers, a paramount role can be played by law schools and educators. I mean, when I studied law in the 90s, during the 90s, nobody, at least in Europe, knows about ADR. I remember that I studied on a book of 1,000 pages, just the last 10 pages over 1,000 were talking about arbitration. No, not a single word on mediation. Today, I think that law schools are undertaking brilliant initiatives in order to educate and create enthusiastic professionals. I almost daily speak with law students who are thrilled about undertaking this path, and they ask me how they can gain my experience and to tell them about my experience. So I think that this is a huge role to be played. Well, coming more closely to the today's topic, which is hybrid mechanism. I think that a very good role is played by SIMC and TIAC with the Med-Arb protocol, but I would like also to, but I'm not the more entitled person to describe it here today, of course. And I would like to mention also the role of the International Mediation Institute, which is under the acronym IMI. And for those who may not know IMI, IMI is a non-profit organization based in The Hague, which is supported by mediation users and providers whose scope is properly to set and rise mediation standards globally. And IMI has purposely set up a mixed mode task force for developing model standards and criteria for the combination of different dispute resolution processes. And the task force is currently exploring very interesting issues, in my view. Most of them have been already addressed earlier today, which are if and to what extent should the arbitrators encourage the settlement of the dispute, or in what ways, if any, might non-adjudicative and adjudicative neutrals appropriately communicate when working together on the same disputes, whether in a sequential, parallel, or consecutive manner. And further, what combination of non-adjudicative and adjudicative processes are most appropriate in the management of conflicts involving ongoing relationships? Or what is the proper protocol to be followed by arbitrators and institutions when parties ask them to convert a settlement agreement into an arbitration award? So they are deepening, are trying to work for offering guidance to practitioners, lawyers, providers, and so on, to properly and adequately tackle the issue. Lastly, just a very few words on what the TIAC is doing for encouraging the use of hybrid process. In fact, I had the immense privilege to participate in the setting up of the TIAC mediation roles. And of course, with no intention of anticipating what Diana Bajzakova is going to say later on, I'm concerned to point out that the TIAC mediation rules are really conceived for being flexible and adaptable to hybrid process, whether commercial or investment. And they are suitable through a mechanism of flexible deadlines and flexible provisions for both Med-Arb processes and mediation windows arranged in the adjudication timetable. In so doing, TIAC is also on the same wave as ICSID in the investment dispute landscape, as ICSID as well is conceiving its new set of rules as suitable to be adopted for both standalone and hybrid processes. So I think, and I would say, stay tuned on TIAC mediation rules for the future and most up-to-date hybrid processes. Thank you.
Thank you so much, Chiara. And we'll hear more from Diana herself later at the end of the webinar. Mushegh, so for you, coming from the largest and most powerful international organization, the United Nations, what is your perspective on what is the role of international organizations?
Yeah, I think my colleagues have touched upon some of the other players, if we can say, on an international arena, and those could be international centers. So let me touch base on the international organizations per se, intergovernmental organizations. And I think the United Nations plays a huge role and in different agencies. One role that I see on a daily basis, the models and mechanisms that we develop for internal disputes. And I think the international organizations, most of the UN agencies that have systems using either Med-Arb or Med or Ombudsman mediation, those type of methods for workplace disputes. In the Office of the Ombudsman, we when I came on board, we started developing mediation, and now I have about 63 mediators on the global mediation panel, and that includes everywhere in the world. So essentially, we're trying to cover the entire 190 country offices, but now we're developing also arbitration systems, and we're because some of the known staff. So if you are not an employee of a UN, the only recourse that you have is arbitration. So that's where the Med-Arb model is coming, into play, and that will be pretty effective, hopefully. Not our office will be doing the arbitration because we are informal, but we are putting together two lists, which can play a huge role in terms of promoting Med-Arb. And I agree with Wee Meng about the co-mediation. That's actually one of my favorite models about co-mediation, and I saw that one of our participants also commented on that. Thanks for that, because that's one of the greatest tools that the dispute resolution practitioners have created. And in our office, I tend to use co-mediation model whenever we have a first newcomer mediator, just to see the style, how they are performing as a mediator, whether we can help them to understand the cultural differences. And just to give an example, a couple of weeks ago, I had to do mediation where one party wanted to speak Portuguese and the other party said, no, I can't speak, I'm fluent in Portuguese, but I don't want to speak Portuguese. I will do English, because you have to secure an English speaker mediator. So we had to really navigate through that, and it was very interesting. And I absolutely agree with Wee Meng and other colleagues who would say the cultural context, languages, and there are so many models. I use the Hofstadter model. We start understanding whether, how the cultures clash in mediation and so on and so forth. So international organizations can play a huge role in that. The other thing that I would mention very briefly, that there's a lot of role that the member states within international organizations play. And that, of course, United Nations is a wonderful example. UNDP does a lot of projects around access to justice in different member states, trying to promote mediation. The World Bank has this enforcement of contracts kind of feature that every year they publish doing business, and that's part of it. So that's another thing that the international organizations are doing. And finally, I want to mention the creation of dispute resolution systems and platforms that, for example, Ancetral is a terrific platform, the working group is a wonderful work that is now being done to reform the investor state mechanism. And World Bank and ICSID, Singapore Mediation Convention, and those type of things. So there's a lot of things that international organizations do, but my message would be, it's not only that you can rely on one platform. In order to promote, you need to have TIAC, you need to have ICSID, you need to have local mechanisms, and then also to leverage from whatever the mechanisms are coming from international organizations.
Thank you, Mushegh. We'll now move to sort of the last round of questions, but before I go there, I wanted to encourage our participants to start posting their questions on the chat, and we'll see if we can get to at least some of them. So please do so in the chat function. Wee Meng, so what are the important qualifications when considering that you consider when recruiting international mediators, and what are other requirements for mediators to be involved in hybrid mediations?
Sure. Before I answer that, I just want to give a shout out to UN, right? Without UN, you won't have the Singapore Convention. I think they've done so much to encourage mediation, and with the convention, I think we're going to see a complete change in the years to come. This is just the beginning. And I think, Mushegh, you mentioned ICSID as well. We were just talking to ICSID just about 3 months ago with the working group 3 that's happening right now. There's a lot of interest in something as complex as investor-state dispute. You can't get more complex than that. But even these extremely complex disputes, they are considering mediation, and that's really the great news. With regard to your question about what are the qualifications one would look at when we think about international mediators, I think I would put them into 2 buckets. The first bucket would be what I call mediation skills. So you need someone who is trained in mediation, who knows how to manage the process, who knows how to draw out the interests of the parties, who is patient and listening and able to manage emotions, sensitive to culture, etc., all the things that we teach in a mediation class, whether in school. Chiara, you mentioned that maybe you didn't get that much education about mediation, and we are doing that right now, right, all over the world. So all those mediation skills are very, very important. That's one bucket. The second bucket is really the deep technical skills. So whether it is infrastructure, IP, Chiara, you mentioned that, whether it is investor-state disputes, whether it is joint ventures, and we see all of this in a lot of the international disputes. It may not be a lawyer, it may not be, it may be an accountant, for example. Especially we've seen several accountants being very good mediators because of their deep technical skills to look at joint ventures and the value of the business, etc. It may be engineers with the deep technical skills for a lot of these infrastructure projects. But I have to caveat that by saying that whether it's a lawyer or an engineer, you must not be too quick to give a solution. You must not, as the professional in the room, say, I know how to solve this problem, and I'm going to tell the parties how to solve it. And if you jump too quickly to that, you do not give the parties the opportunity to talk about their interests, talk about what's really important, and they may not take very well to being told what to do, right? Especially in a facilitative mediation that Chiara talked about for international disputes. So you have the mediation skills, but you also have the deep technical skills, and you almost have to hold it back a little bit, have the technical knowledge, the lingo, the understanding, the experience, but hold that back a little bit so that you can employ the mediation skills to bring the parties together for a much richer solution, and really creative solution that meet the parties' needs. I'll give you one quick example. We had a case, an infrastructure case, where an architect was being sued by the developer, or rather, sorry, the other way around. The architect was suing the developer. This was in a Southeast Asian country. And at the end of the day, you would think the architect is only asking for money, but no. What the architect wanted was recognition he's being recognized for his contribution to that development. And that development went on to win a lot of awards. So he wanted his name to be reinstated into that development. And that was that key that helped to resolve that problem. And you need good mediators to be able to draw up the interest in order for the parties to really come to a resolution that both sides are happy with. This is often not just money, it's something else that's important.
Thank you, Wee Meng. This is really very fascinating, and I regret that we only have 1 hour, because this could last for days. But I'll turn to Chiara with a question about what is the state of hybrid mediation in the European Union countries, and how can we draw some of these new developments beyond the EU?
Yes, thank you, Diana. Well, generally speaking, the EU experience shows a lower presence of regulated Med-Arb mechanisms in comparison to the Far East landscape. The explanation which I personally give to this phenomenon is that, or maybe the historical skepticism of European legal culture toward the so-called double head practice of the arbitrators acting as mediator and vice versa, and the Pandora vase who was mentioned earlier. And this skepticism may have prevented the development of such mechanisms and standards in Europe. But that being said, it must be noted that the modern international mediation and arbitration rules offered by leading European institutions put at disposal flexible and adequate room for setting up a case-by-case appropriate hybrid process. I would mention just 2 examples. And one of the first of the 2 is Article 14 of LCIA arbitration rules of the London Court of International Arbitration, which provides that the arbitral tribunal general duties, I'm reading, at all times during the arbitration shall include a duty to adopt procedures suitable to the circumstances of the arbitrations, avoiding unnecessary delay and expense, so as to provide a fair, efficient, and expeditious means for the final resolution of the parties' disputes. So what has to be noted is the wording of the article, which is not in terms of final decision of the arbitral tribunal, but rather final decision of parties' dispute, which means whatever it may be. And in my opinion, this may empower or disempowers the arbitral tribunal to encourage the parties to try mediation and to arrange in terms of timetable an appropriate window within the arbitration procedure. Furthermore, the ICC guidance on mediation of Belt and Road disputes highly encourages as well the use of mixed mode proceedings under the ICC mediation and arbitration rules. Coming to the second part of your question, Diana, about mechanisms and best practice to be adopted and perhaps exported beyond the EU, I would like to mention the provision contained in the Italian Act on Civil and Commercial Mediation, which was enacted in 2010 as implementation of the EU Directive 1452 of 2008, EU Directive on mediation, of course. And key provision of Italian legislation in the field of mediation, which is applicable to transborders dispute as well, are mandatory mediation and immediate enforceability of settlement agreement arising from mediation procedure. That is why I have found extremely fascinating take part to the session of Working Group 2 of UNCITRAL during the creation of the Singapore Convention. Well, the Italian Act while keeping the process entirely voluntary and going beyond the framework outlined by the EU directive, regulates the arbitral tribunal duties and the parties' rights in case of interaction between mediation and arbitration arising from an Med-Arb clause, sorry. Specifically, this provision sets forth that in case the mediation process is not concluded at the moment of the commencement of the arbitration proceeding, the arbitral tribunal, by objection of the interested party, so not on its own motion, and it is a consequence of the fact that it is an entirely voluntary process, shall suspend the arbitration proceeding so to permit the conclusion of the mediation process. So I think that, or I don't know if this instrument, it is worthwhile to be exported beyond the EU in 2021, but what I consider interesting is that given that this provision is entered or has entered into force about 11 years ago, I think it can be taken in consideration as a positive example of how encouraging means of appropriate dispute resolution. I think that beyond of all that we have been saying here today, the concept to remain focused on is appropriate dispute resolution. So I will stop there.
Thank you so much, Chiara. Mushegh, could you tell us, how do you promote mediation within the Office of the Ombudsman for UN funds and programs? And what about specifically hybrid mediation?
Thanks very much, Diana. I know that we're running out of time, so I'll be very brief. As you said, we can speak about this for days. But let me give you a very brief context so you can understand what the Office of the Ombudsman for Funds and Programs does. I, on a daily basis, deal with disputes where parties, because of a conflict, they will have health problems, they will be in a bed, not being able to go out of the room, they will, for years, they may not talk to anyone because of the conflict. They may be deprived of their job, they may lose their job, sometimes they will lose their family because of the insurance and so on and so forth. So it's very complex. And the way how UNICEF was addressing this is through mediation. UNICEF thought, because of the, and it's publicly available, that report, which is called the ITF report, UNICEF thought that one of the methods to address the culture could be mediation. So they put together, they asked the Office of the Ombudsman, they put together the mediation program, which I came on board and very lucky to lead the team to promote mediation and to encourage people to talk to each other, to have a dialogue rather than, try to escalate the dispute. Within this already a year and a half, now we have about, as I discussed, about 60 mediators, and we have tripled the number of mediation cases in the office. We have 97% of a success rate, knock on wood, which means that almost every case gets settled, and that, it's just a different dimension when people settle this type of disputes. It's commercial dispute is a, they shake hands, you allow people to continue doing business. But this is more, sometimes it could be life and a health situation. It could be, that I exist or I don't exist, or my pride is protected or not. It's a lot of things when, they are on the table. So here it comes that the mediation program is used for that purpose, to give the parties an opportunity to be heard and to solve their problems. And now, just taking the opportunity, we spoke about the arbitration project. I just wanted to say that today is our deadline. If you are interested in applying for the arbitration, one of the arbitration projects, that we have an arbitration counsel roles and we have an arbitrator roles. And this is a unique program because it's not like another list of counsel and arbitrators. We want to give the opportunity to the organizations that we serve and the non-staff members to be able to have access to arbitration services. And we have come up with a pledge, which means that we are committing to a more efficient arbitration, And that means you have to commit to a pro bono hours for arbitration cases. You have to have certain limitation on pleadings length. You have to have a document-based arbitration, certain time period, limited time period for arbitrations per se. And finally, you must encourage mediation. If you are okay with that, you can be part of our list. And that's where we are kind of combining the mediation arbitration, because we believe that if you want to work in efficient arbitration mechanisms, at the back pocket, you have to have mediation as a tool. And that's what we're doing. I'll stop here. I know we're running out of time. I'll not talk about all the cases that we handle or what are the achievements. I think you can go on our website and take a look at the annual report and the new mediation newsletter that we have put together. But if there's any question, I'll be more than happy to address them. Over to you, Diana.
Thank you, Mushegh. We have to be conscious of the timing, but I want to thank each of you for your insightful and dynamic presentations. I feel like I've learned a lot just within this hour, and I really look forward to further events on mediation and hybrid mediation. And certainly, you know, we think that this is the trend that we, as being an arbitration practitioner, I'll have to watch carefully. I would like to turn the floor to the director of the Tashkent International Arbitration Centre, Ms. Diana Baizakova, for some concluding remarks. And if we have any questions at the end, I don't see any, let's see if we can address them. Thank you.
Thank you so much, Diana. And it is my pleasure to see my esteemed colleagues discussing so energetically and so enthusiastically various topical issues in the field that is indeed gaining momentum globally, and more so with the increasing number of the signatories to the Singapore Convention. And I am also very much delighted that this event is the first in the series of webinars organized in the lead up to Uzbek Arbitration Week, which will be held in Tashkent on the 6th to 10th of September. So it is my pleasure to invite everyone to attend the first inaugural arbitration week in Uzbekistan. Very briefly, as those who attended our earlier events may know, that we are a fully operational international arbitration center. And as of today, we have received 23 requests for arbitration. And all of these cases are with international element. Notably, the very last request for arbitration for a commercial case that we've received, neither party was from Uzbekistan. So the claimant was from Russia and the respondent was from Singapore, which is, I think, is an interesting and notable development. Yes, so, and with all the drum roll that it deserves, I'm happy to announce that TIAC is launching TIAC mediation rules and services to address the rising need for mediation services in the region and beyond. I'm very honored that our colleagues from the Florence International Mediation Centre and the USAID have assisted us with that important milestone, and Chiara was very much instrumental in helping us put together the necessary infrastructure and the state-of-the-art mediation services. So the mediation rules will be shortly available on our website. And last but not least, we will be having a separate event during Uzbek Arbitration Week dedicated to the discussion of the TIAC mediation rules, amongst others. And you're more than welcome to register and stay tuned for further program updates. My colleagues will now leave in the chat box the link to Uzbek Arbitration Week for you to have a look. And last but not least, once again, on behalf of TIAC, I would like to extend a huge thanks to all the excellent speakers, as well as Diana Tutieva for your outstanding moderation. Thank you so much.
Let's see. Thank you so much, Diana. And again, thank you to our panelists. And please stay tuned for the next webinar through our TIAC Spotlight series. Thank you.
Thank you, everyone. Thank you, Diana.
Thank you. A true pleasure.
Thank you so much, everyone.